In 2006, the Commission of Inquiry into the case of Maher Arar found that Canadian officials had contributed to the detention and mistreatment, including torture, of Mr. Arar. The government had in fact shared erroneous information with the United States. Mr. Arar was subsequently cleared and compensated. A second commission had similar findings. Canadian officials had contributed to the detention and mistreatment, including torture, of Canadian citizens Abdullah Almalki, Ahmad El Maati, and Muayyed Nurredin. The government has yet to apologize to and compensate these men. The government has yet to implement the Arar Commission recommendations for stronger and more integrated oversight of security agencies to ensure that these abuses never happen again. The Arar Plus 10 conference, held in October 2014 in Ottawa, reminded us of what the Canadian government and its agencies have done in the name of national security.
When you put two documents together, you get a terrifying picture. The RCMP, on the exact same day that they sent to Syria, suggesting to them that I was an imminent threat to the national security and public safety of Canada, on that exact same day, their own internal document said, O Division Task Force are presently finding it difficult to establish anything on him other than the fact that he is an Arab running around.
We discovered in the closed hearings that CSIS misrepresented the polygraph test of one of the sources. They said the polygraph test showed that the source was truthful. After examination by the judge and the special advocates, we found that he was found to be untruthful. Now, there is a situation where you're totally reliant upon government officials to be honest in the presentation of their evidence. They weren't.
Our nightmare began on December 10, 2002, when my husband was arrested under a security certificate and thrown in jail. Deemed a threat to national security, he was taken away from our family, and we were never given the reasons why. His public counsels kept in the dark. He was given a summary of allegations, every sentence starting with, we assume, we believe, we think that in the past, present, or future, he may be a presumed terrorist or a so-called sleeper agent.
Most of the information that we hear in the secret hearings are either from CSIS human sources or foreign agencies. In the information you get from foreign agencies such as the CIA, they send information to Canadian authorities, and the information isn't even sourced. In other words, you don't even know where the CIA got the information. And there is no way that any lawyer can cross-examine that or test that kind of information. Governments have lied in the past. They may in the future.
We know that when Canada shares information, sometimes it can be incorrect. We also know that when foreign states share information, particularly if they have a bad human rights record, the information can come from human rights abuses and torture. The information can be dead wrong.
Crimes against humanity were carried out in Guantanamo Bay. And abandoned there was the only youth, a Canadian boy 15 years of age, Omar Khadr. The fact that Omar suffered over 10 years of abuse and torture in that hellhole called Guantanamo Bay from the age of 15 should come as no surprise to any one of us here today.
Who in this room wouldn't sign a confession with 40 hours of beating?
How is this justice? All original evidence in our case destroyed. main informant filling his lie detector tests and providing untruthful statements leading to false allegations, solicitor client calls listened to, illegal raid at her home on the eve of a hearing, evidence deriving from torture.
Over 12 years ago, when I landed at Damascus airport, almost immediately detained, taken to a place called Fara Palestine, which is internationally known as a torture house. And I found myself on the ground facing the floor in this position, which is called Cela, and they started, very fit men, hammering the soles of my feet with electric cable. This is another type of torture that I was subjected to, using a car tire, being squeezed and yanked in a car tire. This caused permanent damage to my number of areas in my body. This is another type of torture that I was subjected to, among others, notably after RCMP liaison officer went to Syria and with the help and presence of the Canadian ambassador to Syria, met with the Syrian military intelligence director, the very agency that was holding me, interrogating me, and torturing me. Well, after that meeting, I was subjected to a few days of torture, and that was one of the methods they used at that time.
So the conclusions we arrived at, yes, there were actions of Canadian officials that contributed, directly or indirectly, to, and in different ways, to the detention, to the mistreatment, and we included in mistreatment, torture.
I read with interest a report in 2013 by the Open Society's Justice Initiative called Globalizing Torture. What was striking about that is it finds Canada prominent among 54 countries who knowingly participated in the US programs involving secret detention and extraordinary rendition. Canada is one of a much smaller group of countries in the world than 54 who actively participated in the rendition and torture of their own citizens. That's never been reported. It's never been commented upon.
For 12 years, we have been dehumanized, humiliated, put into question, even under oath. You testify, you are a liar. You don't testify, you're hiding something. Put yourself in our shoes and ask yourself, would you accept being detained without charge and kept in the dark? Would you accept that process for yourself? Would you fight back? In our last Supreme Court of Canada decision, they admitted being uncomfortable holding secret hearings. Then why are we allowing it to happen in the first place?
How could all this happen in a country that promotes itself as a champion of human rights in the world? There is pressure today, in the context of events in Canada and elsewhere, to increase the powers of security and intelligence agencies without increasing their oversight. The risk that these abuses and violations could happen again is higher than ever. How can we prevent this? What needs to be done now?
Secrecy is wrong, it hurts people, and it should go. There has to be meaningful, fair procedures at every level, not just the federal court. And there has to be oversight to make sure that these things improve rather than get worse.
Justice O'Connor, who led the Maher Arar inquiry, recommended that we have robust, integrated, and comprehensive oversight of security bodies.
I've read and reread Justice O'Connor's recommendation for integrated oversight. So we've heard a little bit about some oversight, but we have no meaningful oversight unless we adopt recommendations like those that he put forward.
If you have a system, he said, where you've got all these independent at arm's length oversight bodies, one for the RCMP, one for CSIS, another one with none at all, how do you get to the bottom of a serious problem where there's a violation of human rights or a violation, because their mandate is too separate and truncated.
Governments have been, importantly, very much guided by one fundamental principle that they themselves recognized as the very corner to a peaceful, stable, and just world. Governments knew that there were some rights that can never be violated, no matter the threat, challenge, or emergency. That includes the right to life, the protection against torture, and the freedom of thought, conscience, and religion. Human rights do not stand in the way. They are, in fact, the very basis and foundation of freedom, justice, and peace. And the combination of those three concepts surely is the very definition of security.
The lessons of history tell us that real, effective, and enduring security of persons, of our values, of our country, and of the international order is achieved exactly by means of the scrupulous respect for human rights and fundamental freedoms for everyone under the rule of law. In the absence of these, none of us is secure.
More than a dozen police, intelligence, and government agencies are involved in keeping Canadians safe in the context of national security operations. They include local and provincial police, the RCMP, Canadian Security Intelligence Agency, Canadian Border Services Agency, Transport Canada, Canadian Revenue Agency, Communications Security Establishment Canada, and many others that have little public profile. Some have weak or inadequate independent oversight, some have none. In June 2015, the new Anti-Terrorism Act, or Bill C-51, increased police powers, spying on communications, and information sharing, opening the door to further potential abuses. ICLMG opposed the new act and asked for its repeal. In the coming months, ICLMG will be working with other civil liberty organizations to require from the Trudeau government that any new legislation should respect the human rights and the privacy rights of all Canadians. At the very least, any new measures must be accompanied by a robust oversight and review mechanism, such as the one recommended by Justice O'Connor in the Arar Commission report. Here is what you can do. Write a letter or an email to the Honorable Ralph Goodale, Minister of Public Safety. Tell him clearly that C-51 should be repealed, the no-fly list should be open and transparent and accountable, spying on Canadians cannot be permitted, review and oversight mechanisms as recommended by Justice O'Connor should be implemented as soon as possible, and CSIS should not be granted any greater powers. Please support our work. Visit our website. Subscribe to our weekly news digest. Consider donating to ICLMG.